Well, I think that the defense knows exactly what it's doing and why it's doing it. Alan Jackson is a formidable lawyer. He knows where he is trying to go, and where he is trying to go is to show that the phone has been tampered with by the mother. And what he's trying to do with the alleged victim in this case is to show that there were communications between him and his mother, whether they were by text, whether they were email or orally, that would lead her to understand that there may be some incriminating, or rather some exculpatory evidence on the phone about Mr. Spacey that is going to his innocence. The alleged victim in the case seems to have a profound lack of recollection of any communications he has had with anybody at any time.
Yeah, and what was happening there just at the moment that we broke away was the defense was asking him if he was aware of the legalities with regards to deleting information on the phone, and he said he wasn't aware of that. But I guess they're trying to drive home the point, as they asked him specifically time and time again, did you or anybody that you know delete any information on the phone? And he says he has no knowledge of anybody deleting something from the phone, which doesn't mean that it hasn't happened. Well,
and also we know it's happened because we know already from the state trooper's testimony earlier today that, in fact, there were deletions on the phone, that the forensic audit, as I call it, the forensic examination or data extraction, as the trooper calls it, that it showed there were deletions on the phone. The mother says that she did delete things on the phone, but they were frat boy comments. Mm-hmm. So she is separating out her deletions from anything that would have been pertinent to this case. The trooper said he believes her. Well, I don't know in a court of law if that's good enough, that he happens to believe the mother, and that the mother says, well, of course, basically, without saying it, of course I wouldn't have deleted anything having to do with this case. But we don't know what a frat boy conversation even is. Mm. What if the frat boy material was with his friends about that evening? So whether or not the case is dismissed as a result of the loss of the phone, what we certainly see is that there is plenty of room for cross-examination if the case should go to trial about things that were on that phone that are no longer there.
And the other thing that I think was sort of driven home is they asked him, the alleged victim, if there's that significant gap between when this is allegedly to have occurred, which is in July of 2016,
correct,
and October of 2017, when the police finally became aware of it. And they even asked him to talk about that, and he wasn't even sure when. I mean, he said he thinks it's around October of 2017, and then the lawyer said, well, it wasn't the next day, and he said, no, it wasn't the next day. But just the fact that there's this vague recollection around these events is perhaps one of the other points that they're trying to sort of drive home.
No doubt about that, because there's very little recollection about things that occurred not only on the part of the alleged victim, but again on the part of the police. The idea that the trooper didn't think it was necessary, once contact was made, to instruct the mother or the son or the father or anyone else who would have contact with that phone that they shouldn't delete something, it is really astounding to me. Yeah. First of all, the fact that they gave the phone back is astounding to me. But the damage may have been done long before the police ever saw the phone in the first place. And this is not much ado about nothing. This is very, very germane to this case, because it is rare indeed that you would have during the participation in a sexual act, whether it's voluntary participation that is consensual or whether it's involuntary that is sexual assault, that while this is going on, while you are being touched by another person, that you are texting a woman friend. I mean, that is rather a peculiar fact.
Right.
And when you read the screenshot, what we have is this ambivalence. It has some stuff that's helpful for the prosecution. He has a number of texts saying, help me. And then you have lots of stuff that's beneficial for the defense when he basically is saying, this is my words, this is not what's on the screenshot. Holy moly, this is Kevin Spacey. You know what I mean? And it's Kevin Spacey is paying attention to me. That is definitely a paraphrase. But you can go back and forth when you look at the screenshot, albeit that there are items deleted, and the woman friend is goading him on, to get a photograph, not because it seems he needs help, but because it's Kevin Spacey.
Right.
So you have a lot of peculiarities about the text about that night. So then this group text, or group texts to 7 friends. I mean, what is that about? Is this, oh my God, I've been sexually assaulted, or, oh my God, I've been sexually assaulted by a movie star.
Right.
I mean, it's very, very important to the defense to find out what was in that missing material.
At the end of the day, if material has been deleted off the phone, how can you ever really know?
You can't really never know, and that's the defense's best argument about why the case has to be dismissed, because the defendant cannot get a fair trial without this material.
And that's what. And that's sort of what the judge is trying to ascertain today, because Kevin Spacey isn't there. We were surprised when we realized that he wasn't going to be there today. And I guess all these questions around the phone have arisen, and we knew there was some doubt about the phone before this hearing started. But now it seems that there's some real questions that are left unanswered out there.
Absolutely, because it's not just that the phone is missing. It's what happened to the phone before it went to the police, and then what happened, if anything, to the phone after it went back to the family, which I assume as one member after another will testify today, that no one seems to remember getting the phone, using the phone, knows where the phone went. Maybe they never got it back. And the fact that the trooper didn't even get a receipt when he handed it over to the father. I mean, this is all very, very bad for the prosecution. It's not their fault. It's, the prosecutor who's in court. It's the problem of both sloppiness on the part of the trooper or others involved with this case, but it's also what the mother was doing. Perhaps she thought she was doing it in the best interest of her child, but you can't mess with that phone. It has primary evidence in this case, one way or the other.
Looking just at the live picture we have right now in the hearing room, it looks like as if, I don't know what's going on now, because it seems as if all the lawyers, and where is the alleged victim?
It's hard to say if they're at the sidebar. I can see by the female that we see in the left side of this screen, it appears to me that they may be up at the bench still talking with the judge, because that may make some sense. Now something, there's with this kind of motion, we have Alan Jackson back at his table. So they're either going. I
think they're taking a recess.
They're either going to continue or they're going to take a recess. There's no two choices.
All right. Well, we just lost a shot. So
okay.
let's.
But the usual things that happen in Massachusetts courts are that they recess between 1 and 2.
Oh, okay.
That's their quote-unquote habit.
Right.
However, what you have here, because you have one judge in Nantucket, this is his court. He really can decide, because it's not like he has to deal with the jury. It's right now he's not dealing with any other cases. If he wants to recess from 1:15 till 1:45, he has the power to be able to do that. But we really don't know unless that shot comes back.
I think the producers in the control room believe that they are taking a 15-minute recess. That's what they just heard. So we are going to take a quick break.